Hello everyone, welcome to Indian Current Affairs podcast channel. Today we are going to discuss some of very important MCQs related to Indian polity. Let's start the first question. Consider the following statements regarding the High Court judges. First one, the High Court judges on retirement are debarred from practicing in the Supreme Court as an advocate. Second one, violation of the Constitution is the only ground for the removal of an High Court judge. So which of the following statements regarding High Court judges are correct? So if you see first statement, this statement is wrong, because if an High Court judge is retired, then he can work in practice in the Supreme Court as an advocate, and also he can practice as an advocate in other high courts where he is not worked. So he was only debarred from working in high courts which he already worked there. So others, for example, if an High Court judge is worked in Andhra Pradesh High Court, then he is debarred from working as an advocate in Andhra Pradesh High Court only. He can practice as an advocate in Kerala High Court or Uttar Pradesh High Court, any other state's High Court. If he is working in 3 or 4 states, then only in that High Courts only he is unable to work as an advocate. Remaining all other courts he can work as an advocate. Now see the second option. This statement also wrong, because violation of the Constitution is the only ground for removal of the High Court of judge, because it is not a reason for the removal of an High Court judge. High Court judge or Supreme Court judge can be removed only in 2 situations. First one is proved misbehavior. Second one is incapacity. So in this only cases he can be removed. So if you see the explanation, High Court judge can practice as an advocate after retirement in any High Court other than where he worked as a judge, and can also work in Supreme Court as an advocate. Both HC and HC High Court and Supreme Court judges can be removed only in cases of proved misbehavior and incapacity. So next question, consider the following statement. The Appointments Committee of the Cabinet is responsible for appointing senior officials to key positions in central government and public sector undertakings. Second statement is the ACC is chaired by the Ministry of Home Affairs. So which of the following statements are correct? So if you see, first statement is correct, second one is wrong, because Appointments Committee chaired by Prime Minister, not by Home Minister. If you see the explanation, composition of the CCA, the Prime Minister of India heads the CCA. Other members typically include key ministers like the Minister of Home Affairs, Minister of Defense. So although the exact composition can vary depending on the Prime Minister's preferences. Functions of the Cabinet Committee on Appointments. Senior bureaucratic appointments. The CCA is responsible for approving appointments to key positions in the civil services, such as secretaries, additional secretaries, and other high-ranking officials in the central government. It also oversees appointments to public sector undertakings, regulatory bodies, and other significant government organizations. Appointments in the armed forces. The CCA approves the appointments of a senior military officers, including the chiefs of Army, Navy, Air Force. Appointments to constitutional bodies. The committee plays a role in the appointment of key officials in the constitutional bodies like Election Commission of India, Union Public Service Commission, and the Comptroller and Auditor General of India, etc. So next question, consider the following statements with reference to the Directorate of Enforcement. So about ED. So the ED is a multidisciplinary organization that investigates offences related to money laundering and violations of foreign exchange laws. Second statement, the ED functions under the Department of Home of the Ministry of Home Affairs. Next one, third statement, the ED is authorized to take suo motu actions in cases of money laundering. So which of the following statements are true regarding ED? So first statement is correct. The ED is a multidisciplinary organization which investigates money laundering cases and violation of foreign exchange laws. This statement is correct. If you see second statement, this is wrong, because ED functions under the Department of Finance under Finance Ministry, not under Ministry of Home Affairs. Second statement is wrong. If you see third one, the ED is authorized to take suo motu actions. So suo motu actions means no one need to give complaints. So there is no need of anyone complaint. So suo motu only ED can take actions, but it is wrong. So ED can do in any investigation only it has police case or anything else. Otherwise it is not possible to do suo motu actions. If you see the explanation, ED functions under the Department of Revenue and Ministry of Finance. ED cannot take suo motu actions. It requires a complaint to be filed in the another agency or police first before it can investigate. So under the Department of Revenue, Ministry of Finance. Next question. Consider the following statement with reference to the Prohibition of Child Marriage Act 2006. The act applies only to Indian citizens residing within the India and does not extend beyond the Indian borders. Second statement. The age of marriage is set at 21 for boys and 18 for girls, and any marriage below this age is considered illegal and punishable. Third one. Child marriage prohibition officers are appointed in every state to prevent child marriages and prosecute offenders. So which are the following statements regarding Child Marriage Act correct? So answer to the Prohibition of Child Marriage Act 2006. So first statement is wrong. If he is an Indian citizen, he is in any country, he is obligated to this law. So first statement is wrong. Second one is the age of marriage. This statement is correct, and third one also correct. Child marriage prohibition officers are appointed in every state to prevent child marriages and prosecute offenders. Next question. Next explanation. Statement 1 is incorrect because the act applies to all Indian citizens irrespective of religion and beyond India. Next question. Under the Right to Education Act 2009, which section mandates that private schools reserve 25% of their seats for children from economically weaker sections and disadvantaged groups? So about this Right to Education 2009 Act, this is recently in news. In Maharashtra, what government of Maharashtra did, state government, they said if any private school nearly 1 kilometer near to the public school, then there is no need of providing 25% reservation for economically weaker sections and disadvantaged groups. But Supreme Court said this is unlawful and removed that act. So it is mandatory to every private school also to provide 25% of seats for children from economically weaker sections and disadvantaged groups. So it is mentioned under which section of Right to Education Act 2009? Section 10, Section 12 of 1, Section 15, Section 20. So answer to this one is Section 12 of 1. Section 12 of 1 in this act mentions that it is mandatory to provide 25% of seats for economically weaker sections and disadvantaged groups. So if you see the explanation, Section 12 of 1 of the Right to Education Act 2009 requires all private schools except private unaided minority schools to reserve 25% of their seats at the entry level for children from economically weaker sections and disadvantaged groups. This provision aims to promote social inclusion and ensure that children from all backgrounds have access to quality education. So next question. Which of the following is incorrect regarding the Central Reserve Police Forces? So we have to find incorrect statement. The CRPF's primary role includes assisting in maintaining law and order and internal security. Second one, each CRPF battalion consists of 7 companies with each company commanded by an assistant commandant. Cobra, a specialized unit within the CRPF, was created to combat the Naxalite movement. The CRPF is a central armed police force under the Ministry of Defense. So which of the following statement is wrong? Answer to this one is D, because it comes under Ministry of Home, not under Ministry of Defense. CRPF comes under Ministry of Home. So if you see the explanation, the CRPF is under the Ministry of Home Affairs, not the Ministry of Defense. Next question. Under what circumstances can a governor reserve a bill for the President's consideration according to the Indian Constitution? A bill that is opposite to the directive principles of state policy, a bill that deals with compulsory acquisition of property under Article 31A, a bill that endangers the position of the State High Court. So under what circumstances can a governor reserve a bill for the President's consideration according to the Indian Constitution? So governor must consider that bill for President's consideration when it violates Constitution. So it is one of the obligation. So if you see the explanation, these are all constitutional provisions. DPSPs are constitutional provision. So Article 31A is in a constitutional. So a bill that endangers the position of State High Court. High Court is also constitutional body. So In all these cases, a governor reserve a bill for the president's consideration if any state government makes on law on them. So if you see the explanation, provisions under Article 200, the governor may reserve a bill for the president's consideration instead of giving or withholding assent. This reservation is mandatory in cases where the bill in the governor's opinion may conflict with the provisions of the constitution. First one, the bill might affect the larger interests of the country or the relations with the state with the union government. Second one, next third one is the bill deals with subject on which president's prior sanction was required but not obtained. So in all these three cases, governor can prefer that one to the president consideration. So a governor may reserve a bill for the president if it is opposite to the DPSP, involves compulsory property acquisition under the Article 31A, or threatens the state high court position, because all these are in constitution. So if anything against this one bill formed in state government, it is violation of our constitution. Which of the following provisions are part of the center-state financial relations? So distribution of taxes, power of borrowing money, grants in aid. So which of the following provisions are part of center-state financial relations? All these are part of center-state financial relations. Part 12, Article 264 to 300A of the Indian Constitution states about center-state financial relationship, under which variety of things are given, such as distribution of taxes, borrowing of money, and grants in aid. The next question, which of the following statements are correct regarding consolidated fund? So Parliament is the custodian of the consolidated fund of India. Next one is no money can be withdrawn from the consolidated fund without the approval of the Parliament. So which of the following statements regarding consolidated fund is correct? So we have to know three types of fund. First one is consolidated fund, next one is contingency fund, next third one is public account. If you know the differences between these three, then it is easy to understand. So for this question, these two statements are correct. So to know what is consolidated fund and contingency fund and public account, see the explanation. Both the statements are correct. Parliament is the custodian of the consolidated fund of India, and no money can be withdrawn from it without Parliament's approval. If you see about consolidated fund of India, constitutional provision, Article 266 of 1. Purpose. This is the most important fund of the government of India. All revenues received by the government, loans raised, and money received in repayment of loan are credited to this fund. Usage. All government expenditures except those made from the contingency fund and the public account are made from this fund. This includes both revenue and capital expenditures. Parliamentary approval. Withdrawal of money from this fund requires the approval of the Parliament. This ensures legislative control over the public finances. Components. It is divided into two parts, revenue and capital division. If you see the contingency fund of India, constitutional provision, Article 267 of 1. Purpose. This fund is used to meet unforeseen expenditures that cannot wait for the approval of the Parliament. Usage. It acts as an impressed account, meaning it is used for emergency purposes. The fund is at the disposal of the President of India, who can authorize expenditure from it. Parliamentary approval. Although the initial expenditure does not require parliamentary approval, the amount spent is subsequently recouped from the consolidated fund of India, requiring parliamentary sanctions. Next one, corpus. The fund has a fixed corpus which is currently 500 crores. So next question. Next, public account of India. Constitutional provision, Article 266 of 2. Purpose. This account deals with transactions where the government acts as a banker. It includes funds that do not belong to the government but are held by the trust. Held by it in trust. Usage. Examples include provident funds, small saving collections, and other deposits. The government does not need parliamentary approval to withdraw money from this account, as it is essentially holding the money on behalf of others. Components. It includes items like provident funds, judicial deposits, saving bank deposits, departmental deposits, and remittances. So I hope you understand the difference between these three: consolidated fund and contingency fund and public accounts. Next question. Consider the following statements with regards to gender budgeting in India. The gender budgeting statement was first introduced in 2005 and 6. This year's share of allocation to pro-women schemes stands at approximately 6.8% of the total budget expenditure for 24-25, which is below the usual average over the years. MGNRGS has the highest allocation among schemes for women in the JBS. What is first of all gender budgeting in India? So what is gender budgeting? Gender budgeting means now in the time of budgeting, finance minister said we allocated this much money for the farmers, this much money for the youth, this much money for the businesses, this much funding for the infrastructure. Similarly, some money is allocated for women. It is not directly related to the women schemes. It may be any scheme. How much money in that one women are benefited, so that is calculated. So that comes under gender budgeting in India. So the gender budgeting statement was first introduced in year 2005 and 2006. This statement is correct. The next one is this year's share of allocation is 6.8% for women. Here it says it is the lowest when compared with the past years, but it's wrong. It is the highest. When you consider the past years, it is at 5% of total budget, but this year it is 6.8%. So second statement is wrong. If you see the third statement, MGNR has the highest allocation among schemes for women in the gender budgeting schemes. So this is also wrong because PMAY, Pradhan Mantri Awas Yojana, has highest allocation for women. Next one is, if you see the explanation, Pradhan Mantri Awas Yojana first. Next one is National Rural Livelihood Mission. So after that, MGNR comes. If you see the explanation, statement 2 and 3 are wrong because 5% is average spending for the women in the GBS in previous budgets. Now it is at 6.8%. So it is significant increment. So now in the year 2004 and 2005 union budget, several schemes have received significant allocations aimed at benefiting women. Here are some of the top schemes ranked by their allocated funds. First one, Pradhan Mantri Awas Yojana. This scheme, which includes a substantial component for women, received a significant allocation to ensure housing for all, with all focus on women beneficiaries. Second one is National Rural Livelihood Mission, aimed at empowering women through self-help groups and promoting entrepreneurship. This scheme received a substantial boost in funding. So next question, which of the following statements is true regarding the establishment of Gram Nyayalayas in India? So this is also in recent news because Supreme Court won reports about how many states implemented Gram Nyayalayas in their states. So regarding that one, first statement, Gram Nyayalayas were established to ensure that rural populations have easier access to justice with the intention of providing swift and affordable legal remedies. Second one, these Gram Nyayalayas were proposed by Law Commission of India 114th until 114th report. Next, third one, Gram Nyayalayas handle both civil and criminal cases, not just land disputes and agricultural issues. The Gram Nyayalayas Act has enacted in 2008, but implementation has been uneven across states. So which of the following statements are correct? All these statements are correct. If you see explanation, so all these statements are correct. Next question, consider the following statements with reference to the Special Marriage Act. The Special Marriage Act of 1954 allows interfaith or intercaste marriages without requiring conversion. The SMA applies to people of all faiths across India, including Hindus, Muslims, Sikhs and Christians. In 2003, the Supreme Court ruled that the same-sex marriages are legal under the Special Marriage Act. Which of the following statements are true? So, Special Marriage Act, under Special Marriage Act of 1954, so any persons from different religions, different castes can marry. So first statement is correct. Second statement also correct, but third statement is wrong. Supreme Court said that one, it is not possible to legalize the same-sex marriage under Special Marriage Acts because they say Supreme Court said Special Marriage Act is for different castes and different religions, not for same-sex couples. So that's why it is. They said it is under government. Government need to do any laws regarding that one, and it is not comes under Special Marriage Act. If you see the explanation, Statement 3 is incorrect because in 2023, the Supreme Court ruled that it does not have the authority to legalize same-sex marriages under the SMA. This responsibility lies with the Parliament. Next question. This is the end of the today class. Thank you very much for watching.